they start their budget hearings. So they have no use for much else.
So developers.
That's the fiscal year?
Yes.
Okay.
Yeah. Yep, you just plan it, you just work it into your budget, I mean, into your schedule.
Okay.
That you know, you try to get the applications in so that the staff can be doing their thing, but you're not going to be ready for hearings anyway. So that's how you live through the summer.
That's good to know.
Yeah.
I didn't know that.
Some of them, it's a month, some of them 2 months, some 6 weeks, but a lot of them, they stop their meetings for a period over the summer. And then usually you lose a good bit of December also. They cancel meetings in December. Okay, one thing, and I don't have slides on this because I couldn't find, I was looking for summary kind of information on a case called Brevard County v. Snyder. I referenced it in another set of slides, but I wanted to give you more facts regarding it. It's a Florida Supreme Court case.
Yeah, I just wanted to clarify. I was just looking at my notes from, I guess the last time we met. You said the final exam was going to be cumulative and it would include class lectures 1 through 4, but I heard you many times today say that this is not on the exam. So could you clarify what?
There are no questions on the exam from the slides I did this morning.
Environmental? 1 through 4?
Or airport.
No question.
Oh, and then.
What about the readings already?
You said it was gonna be multiple choice and you were gonna think about how long these other questions were gonna be?
There's more, there's a greater percentage of multiple choice.
Okay.
But there are still short answer. But the short answers really are short answers. I'd say if you can't, it should be 3 to 5 sentences. If you think it takes more than that, look at the question again to make sure that you're answering the question I asked instead of the question you thought I should ask.
Is that part of how many questions?
You're going to have this in your hot little hands in a few hours, really? We really have to do this?
Oh, you have the exam already. So we get started.
We're having.
How many pages is that? I don't mind.
You know, you could have lived in happy ignorance for 4.5 more hours.
Impress yourself.
Too bad. It is. There are 35 multiple choice and true and false questions, and some of them are multi-part, so it's probably more like 39 answers. And there are 9 short answer questions. Short answer questions.
All right.
5 hours.
9 to 35, 9 to 35, 9 to 35, 9 to 35.
And how this helps you where you're sitting right now, I don't know. There you go.
There's 9.
I came across a term. It's called expulsive rezoning.
Expulsive?
Expulsive rezoning.
That is new to me. Where did you find it?
It's in this environmental justice things I picked up in my paper. And what it is you know how zoning and entitlement is supposed to guide development and all the good stuff that goes with it? No, here's a case where the zoning is according to the policy and it's everything in the plan they have. But it's designed to keep minorities in certain areas, and they actually do a thing where they allow industrial use alongside the residential, but only in the areas that they know the minorities live. And it's done deliberately, and what it does, it makes it just a nuisance, and they have health problems and all of that, and so that's where the expulsive part comes from.
So it's a descriptive term for zoning that is intended to
Drive certain groups out.
drive groups out.
Yeah.
But it's not a,
That's illegal.
No, it's legal, and it's legal, but it's at the federal level, it's not. But it's legal because it's consistent with the policy of the local government and the state.
okay, I'm going to go back to, hang on, I'm going to go back to Brevard v. Snyder, because one of the issues in that case is about the adoption of zoning as a legislative matter versus a quasi-judicial matter. So we're going to stop and talk about the standard that applies to the legislative action, because that's what you're describing, is a legislative policy to adopt a group of zoning regulations to achieve a policy. Okay, it's not a site-specific application of those policies, but the adoption of a broader policy.
You see?
But don't, I'm taking the class back. So we'll talk about the standard, the legal standard that often applies to a legislative action is very different than the legal standard that will apply to a site-specific application of zoning regulations to a particular site. So Brevard v. Snyder was a 1993 Florida Supreme Court case. It arose on these facts. There was a property owners had a 1/2-acre parcel on Merritt Island in the unincorporated area of Brevard County, and the property was zoned GU, general use. Miami-Dade County has a general use, which is kind of a
Brevard, right? Brevard.
Brevard, which was kind of a holding pattern type of zoning that allowed 1 unit per acre. As just a de minimis level of development, it was kind of not ready for the big time, so they were going to hold it in a very low density development and low density zoning for the time being. So the Snyders filed an application to rezone their property to a zoning classification that allowed 15 units per acre. And when the planners took in the application, they reviewed it against the comprehensive plan, it was designated for for residential development on the comprehensive plan. And the plan had allowed for 29 different zoning classifications to potentially be considered consistent with the residential land use category. So different densities, from very low to very high density. So the planning and zoning staff reviewed it, and they found that it was consistent with the comprehensive plan, except that it was located in a floodplain. And they had other regulations that prohibited development in the floodplain of more than two units per acre. So they recommended denial. So then they get in front of the Planning and Zoning Board, and the applicants say that the development code, the building code would require them to build above the floodplain anyway, so they don't really have to be concerned about the floodplain. And the Planning and Zoning Board recommended approval of the rezoning. So then they get to the Board of County Commissioners, and the staff withdrew its opposition based upon the application of the building code that would solve the floodplain issue. So they get to the Board of County Commissioners, and the applicant stated at the hearing that really he only wanted to build 5 or 6 units on the property anyway, and it was a 1/2-acre property, so a little bit below the maximum density. But citizens came and spoke in opposition to the rezoning, and the primary concern was the increase in traffic which would be caused by the development. Ultimately, the commission voted to deny the rezoning without saying why. They didn't provide any reasons. So then the Snyders filed suit. They lost at the trial court, but they prevailed in the intermediate appellate court, which is not a detailed. And then it went to the Supreme Court, and the Supreme Court found that the denial of the rezoning was invalid, and described why it was invalid, and this is how we got a new rule of law. So there were a couple of
So
issues.
they see these zoning was that's what they found.
The
Supreme Court.
The applicant wanted a 15-unit zoning. It was denied by the county commission, and then the applicant filed suit. They lost at the trial court level, and they won on appeal. The reason they lost at the trial court level was because historically in Florida, rezoning decisions, whether it was the mammoth rezoning of the whole town or rezoning of a single parcel, they were all considered to be the same kind of action, a legislative action. And legislative actions will be upheld as long as they're fairly debatable, which is a very, very low standard. So generally the courts are like, you're the legislators, we are not. If there's a fairly debatable basis for what you did, we're gonna leave you alone. That had been historically the rule in Florida. What came out of the Snyder case was this separation between broad-based, widely applicable zoning regulations and the adoption of a site-specific regulation. So the Supreme Court of Florida created a different standard. Broad legislative enactments of a new zoning code or the broad application of zoning to a whole area of land, maybe initiated by the city itself, those are still legislative, and those are still protected and upheld on appeal as long as they're fairly debatable. But anytime the application is seeking the application of those broad standards to a specific site, then the standard changes. It's not legislative anymore, where the elected officials get, just sort of debate and decide what policy is going to be. It becomes quasi-judicial. Quasi-judicial is close to judicial. It means that the decision must be based on competent, substantial evidence, and the reasons for the decision have to be stated in the decision. And just like, have you ever watched a legal drama and somebody says, that's an ex parte communication, Somebody talks to the judge outside of the courtroom and the other party isn't present, and that's off bounds, right? That's offsides. You're not allowed to do that. So the quasi-judicial proceeding for land use becomes that way also. The applicant's due process rights mean that he's entitled to make his case in front of the quasi-judicial board, and they can't be influenced by outside communications. So as a practical matter, though, elected officials are in the business of talking to their constituents. And it is problematic if they are not permitted to, have communication with the community activists. Really, that's who they're elected to represent. How can they be prevented from doing that? So what has happened is a disclosure system. What you'll find if you go to a quasi-judicial public hearing, you might hear the city attorney or the county attorney ask for the elected officials to disclose ex parte communication. So the idea is, yes, I talked to the applicant outside of this meeting, and we talked about the project, and I'm disclosing it. And now the applicant, the opponents have an opportunity to, rebut it. It doesn't really solve the problem because you don't really know what happened in the outside meeting, but the theory is that if the communication is disclosed, it at least puts the applicant back on a fair footing to try to rebut whatever the result of the ex parte communication was. And competent, substantial evidence. So let's think about the Snyder's hearing. The residents showed up and they complained about the traffic, and the board denied the request without stating a reason. There's no way of knowing with that kind of record what the basis for the decision was. It could have been racial enmity. It could have been, we hate poor people and we think that they're going to bring poor people in. It could have been something completely illegal and impermissible basis. But without stating the reason, there's no way for the applicant to challenge it on appeal. So the court, this decision requires them to state the basis for any denial. And it creates a record for the applicant to take up on appeal. Also, the other aspect of competent substantial evidence are those modifiers. It has to be competent. So what's competent evidence? If the neighbors don't know anything about traffic engineering, and all they do is come in and say, we don't want more traffic. Do you think that's competent evidence?
No.
You're right, it is not competent evidence. Now, if the applicant has a traffic study that quantifies the increased traffic and describes a method of mitigating it, is that competent evidence?
Yes.
Okay. Is there anything, and that's the problem, is what comes in between. So if the residents step forward and say, I don't know how many more cars it is, but I will tell you that the traffic in front of that school backs out onto the highway every morning. Does that sound like competent
Well,
evidence?
that's observation,
Pardon?
that's a good observation, that's empirical.
It's factual,
Yeah,
it's made by observation.
correct. You can take a picture and that's it.
Yeah, I think that tends to go onto the competent
Right.
Yeah.
realm. Is it gonna be enough? I don't know. But it tends to fall on the line, down the side of competent evidence. Trying to think of some other examples. This building is gonna be so tall that it's gonna cast a shadow on the beach. I'm afraid it's gonna make our beach, in shadow for half the day. If a resident says that, is that competent evidence? I know this is not anything you guys have ever been trained in. I would say not.
Yeah, but there was a case in South Beach about that.
Okay,
They
so
allowed- They built it.
if a study, now it's so easy with Google Earth to do shadow studies, but it used to be you used to have to hire somebody special to do a shadow study. If the applicant
Shadow
comes
study?
in,
They just look at shadows, I mean, I
They
can
call
tell you if there's a
forest
shadow.
tall building shadow.
yeah, you
Yeah,
can
but
go
yeah,
on.
but see, it changes every
No, I'm just saying, like, that seems like the most
Easiest.
easiest job
But
I
that's
could
not
ever.
competent.
But
I understand, I'm not arguing that, I'm sorry, I'm
I
just
mean, the
arguing the
computer
whole, like, they
Yeah.
actually have studies, or a guy that goes out and does studies on shadows.
well, now again, it's so easy with Google Earth now,
Yeah.
but you used to have to
That's great.
hire someone to do a shadow study,
Just more dollars you have to put out for a guy to take a look at a shadow.
and
It is what it is.
Sorry,
it's the consultants. The more technical this whole process becomes, it's like the consultant's bill of relief. But it's better to have a basis on which to make decisions, right?
Right.
Even if you don't like having to do the study, it at least creates a factual record for what the government's doing, and that makes everybody a little bit more comfortable with it. You might not be happy with the decision in the end, but you're like, but at least you know that they gave it a reasonable.
It's rational.
It's rational. So that's the other practical consideration of the Snyder case is site-specific applications, whether it's a site plan, a rezoning of a particular property, are quasi-judicial as opposed to legislative. It requires that the fact finder make their decision based upon what they hear in the hearing and not their own drive-by, literally. Give me just one more second. And the basis of the decision must be supported by competent substantial evidence. And the last feature is this. To appeal one of those decisions, you have to do it based on the record that you created at the quasi-judicial hearing. If you go into a hearing in a very sort of casual, I think I've got the votes for this, and you don't make the record, and then you are sued, you have no record to defend that action, even if you could have made the record below. You can't start over when you get sued. So understand, when you're in a quasi-judicial setting, you'll need a lawyer for the most part, but if you're there without one, you need to make a record. You need to make sure that everything's supporting the decision. If you win, it all gets on the record. And you need to probably have a court reporter there.
Can you give us an example of that, where you,
Of what? Which part?
where you give a public record, if you don't have it on the record?
Well, you can ask questions about, especially if you're there without your lawyer, you can ask questions about the procedure to make sure that you understand when you will get to make your record. So, I'm sorry, I'm here representing myself today. When will I have an opportunity to make a presentation? And, oh, excuse me for interrupting, but can I ask the staff questions about that? You know, you do it, if you end up doing it instead of a lawyer, that's what you do. You have an opportunity to cross-examine the professional staff and the other side's professionals if they have them, and you do it courteously, but you get in there. And if they say, no, you can't make a presentation, that's a good record to have too on appeal. You were prevented from making a record of the decision. Yeah.
Yeah, I'm curious about the way the judgment was framed from the U.S. Supreme Court. How did they,
This is the Florida Supreme Court.
okay,
It's a Florida case.
all right.
But it's based upon general concepts of due process, and I don't know which states will come down and which side of this decision, but they are issues that you will find in the law in every state, because it's really basically due process. So, let's see what the holdings were. So some of the languages, enactments of original zoning ordinances have always been considered legislative, and there are case sites for that. And they only have to be supported under the fairly debatable standard. However, the amendment in that case, so there was an amendment that was comprehensive in nature, and that affected a change in the zoning of a large area, also legislative. And it is the character of the hearing that determines whether or not board action is legislative or quasi-judicial. Generally speaking, legislative action results in the formulation of a general rule of policy, whereas judicial action results in the application of a general rule of policy. I'm just looking for some summary type language. So rezoning actions which have an impact on a limited number of persons or property owners, on identifiable parties and interests, where the decision is contingent on a fact or facts arrived at from distinct alternatives presented at a hearing, and where the decision can be functionally viewed as policy application rather than policy setting, or in the nature of quasi-judicial. And then there's additional language in this case that says that the review of that decision is subject to strict scrutiny, which is a higher standard than the fairly debatable standard. So the appeal is by writ of cert to the circuit court, which you don't really need to know, but it comes under strict scrutiny instead of if you can define some basis, then your decision will be upheld.
Could this case be actually a regulatory taking?
Pardon?
Could it be a regulatory taking?
Regulatory.
The denial of a rezoning could be a regulatory taking if the effect is, to deny all reasonable use of the property. It could be.
Yeah, they could have argued that's what it was, right?
Pardon?
They could
They
have
could have-
argued that's what it was, a regulatory taking.
Sure. And sometimes, I'm trying to think of a scenario where a rezoning is necessary to avoid taking, but okay. I'm just trying to see if there's any other holdings here. And that's really the gist of it. And it changed the way that local governments conduct these hearings. Usually, again, a city attorney will say, this next matter is quasi-judicial, here are the procedures, and they'll outline them for you. And witnesses will be sworn, too. Now, the value, the importance of the evidence comes in here also, because most cities will allow members of the public to comment without being sworn. But the understanding, they'll usually say that unsworn testimony will not be given the same weight as sworn testimony. So members of the public can show up and voice their feelings about the project, and they can choose to do that without being sworn, but they understand that that's probably not going to fall on the side of competent evidence, because they're not going to be sworn and they're just expressing their feelings. They'll still listen, elected officials are still there to listen, but it probably won't have a big influence on the decision. So that is the gist of Brevard v. Snyder. And now, any questions, and I'm just going to be here and I can answer any type of review questions you have, or you can ditch me.
Email the people to you, still have to give them a copy, but you still have to
Go ahead and email. If you gave me a hard copy and didn't email it, go ahead and email it. Again, belts and suspenders, who knows what I'll have with me at any given time.
How will we know when we distribute the grades for the final ND papers?
Last time, I just went from this point right into entering final grades.
Well, you know that there's a functionality in Blackboard where you can publish grades.
You can publish individual assignment grades.
Yeah.
Yes.
I'm concerned about even remembering how to get back in and enter my
Oh,
final grades.
well, then
You
that's-
know, I only do this once a year, and I don't remember from one to the next how to do something.
Yeah.
So I am not sure that I'm gonna do that.
Okay.
But what I'm seeing in this project is the, the number of words that we have to write. So what would be a minimum?
The number of words
Yeah, what
What?
would be a minimum acceptable?
on the paper,
Yeah,
well, your papers are done now, right?
yeah, that done, yeah.
There will be no, your grades will not be lowered because of how short the paper might be. It's all a matter of whether you do well with the words you use. Whether, it really is. When I was a first year law student, we had to do moot court. So we had to do an appellate style brief and argue in front of a mock trial. And, I mean, not a trial, an appellate argument. And I finished my argument early. And I said, well, do you have any questions? And they asked a few questions. I said, I was still on the green light. I had more time left. I said, well, I've concluded, so I'm gonna sit down. And I'm thinking, oh no, it's like I should have used all my time. And I realized then that there's no benefit to using up a judge's time for no good reason. And there's no benefit to writing about something when you've covered it. So you can have short papers. If you cover your topic well, it's not gonna hurt your grade.
But for the benefit of the class, for the people that want to have the most time to utilize for their exam, I would ask that everybody hold your questions out of the class.
No, you're dismissed. If you want to come up and ask me individual questions, I'm
I will say, Dr. Forgy emailed me about the class, the strategy class. If you did not get the email, it's because it's in your junk folder of your school inbox. It happened to me, and so he made it. Please check your junk mail folder of your class student email. You'll find an email he sent out. Well, he sent it to you. The point is we went to your junk mail instead of your inbox. I don't know why it happened to me. About that class. The dates that we're meeting, he's got a bunch of stuff. Today.
I hope you all wrote wonderful papers.
Next paper, right?
Did
Yeah, I'm not sure. I think 40 minutes talking. I'm not sure why we have to do that.
Next week, right?
This is the exam. This is an extra copy.
Especially the land use stuff, that was.
Where all is too.
If you have any trouble with my paper email,
Yeah.
just let me know.
No, I won't X-nay anybody without checking with you.
I resent.
Oh, San Miguel next weekend. I'm excited. Do it.
Get ready. Get ready for San Miguel, capital markets.
Did you also put this?
Let me try to practice now. Greenberg, sorry. You're with Holden? Oh, that's funny. I'm doing diligence on 2
Oh.
Did you see one? Yeah. Oh, my
If anyone wants any sandwiches, I'll do back here.
Tech, I don't know. I have no idea. Those are the initials. What's that?
I'm in March here, somebody else in our firm.
Good, that's the one.
Nothing you can say.
You can't see anything else.
I grew up talking about,
Only dogs and
there were, this said something, it's like,
Also,
what is that?
doing diligence with the investor.
I was, that's the first one, is my question. Okay, thank you.
It's not all. I'm getting my A's mixed up. But how long have you been with them?
Almost 3 months.
Yeah, and what was your Are you on the finance?
I wasn't. I started as a financial analyst.
Did you choose your mentor?
I said, about before you like 3 names.
Yeah.
But he ain't got back to
Do you like the question? You said more than
I'm gonna stop. I heard him sit down and sit back to him.
Exercise.
Anybody's doing anything.
Yeah.
Go ahead and do it yourself.
I'm very good at numbers.
They have windows and they respond to things, you know what I'm saying?
Like 3 weeks ago.
Yeah. See what happened is, he has to work with it, then how many people he gets. He's pretty good at saying on that.
Okay, so I was 16 years old.
I'm not sure what
I
happened.
So I did land use regulation and environmental regulation. And I really realized. I
really did.
Do one more
So
time.
I went to the airport and I
Do
kept
one more.
Yeah, I'm gonna still study.
We'll pick up the mark, especially since you hear that the Argos one is not But you know what happened? That's how they collapse the market, the financial capital, and the cohorts. We're not doing that the way.
Yeah, that I wanted, I want. I'm debating on one last thing, and